Hey, everybody, and welcome to Thursday night. John Skiba here on the Consumer Warrior YouTube channel. And like each and every Thursday night, we do a live stream here where we talk about all things debt related. I am an attorney in the state of Arizona. I work for the law firm of Jackson White. My number and my website, everything's scrolling along the bottom here. And what I do is I help people with bankruptcy and who are dealing with consumer protection type issues. And so the way that we do this each week is if you have questions, if you're on YouTube, you can put them in the chat section and I'll put them up on the screen and we can discuss them. I don't have that set up for Facebook yet, but if you're over on YouTube, you can do that. Of course, I have to do a disclaimer. All lawyers do, as far as if this isn't legal advice. I can't talk specifics about your case, and particularly if you're not in the state of Arizona, I probably don't know the law like I do here, obviously, because I'm only licensed in the state of Arizona. If you need legal advice, I highly, highly, highly recommend you contact an attorney in your state and find that out. This is nothing more than people talking on YouTube. So take that for what it's worth. Real quick announcement before we jump into the questions tonight. I have been in the community section. I've been putting out there that we're going to be doing a boot camp. There's quite a bit of interest in doing that. You know, there's the videos, the tutorials, and all that I do, but really just kind of an A to Z, go through an entire debt collection lawsuit and what some of the tips and strategies are on that. I'm going to be doing it. I put a link in the show notes or in the chat section there that I pinned it to the top there. There's a link if you want to register for that. I'm going to be doing it on the evening of May 19th. That's a Thursday from 6 to 9 p.m. And then I'm also going to do it on Saturday, May 21st from 9 a.m. to noon. And all those times are in Arizona. And I can't always tell you exactly where we're at. I think we're on Mountain Standard Time. Arizona doesn't change with the time changes. And so, but it'll be Arizona time on those things. So I wanted to start off tonight with, like I said, I like to go through the comment section on the YouTube channel. There's a lot of comments, and so I can't get to all of them. But a question I get quite a bit is this one. How do I know when I should just give up and file for bankruptcy? When should we, the question of when should we throw in the towel? And whether you're fighting a debt collection lawsuit, you're just dealing with a lot of debt. And I get this question all the time from people who are looking to file for bankruptcy or just find some relief of whether they just, pull the trigger and just go ahead and do it. The advice I generally give people is, if you're in a debt situation where there's just no way you're gonna be able to pay it back, even if you white knuckle it, you're going Dave Ramsey, beans and toast and all that kind of stuff for usually like a 3-year period. If you think there's just no way you're ever going to make any serious headway into that, I would recommend looking at bankruptcy. Even if you have, we talk about defending lawsuits here and how there are strategies. Sometimes I have people come in, they're saying, hey, Midland Funding's suing me. I have all these great defenses. Let's go ahead and fight this. One of the first questions I ask them is, are there other lawsuits out there, or are there other lawsuits that you're anticipating may be filed? Because if we go through and win one, and that's just the tip of the iceberg, and there's going to be 5 more that are going to replace it, it's going to be more cost effective to just get them all done with once with a bankruptcy filing. It's kind of the nuclear option. It'll get rid of it. You'll recover from the bankruptcy more quickly than most people anticipate. It is true, Chapter 7 bankruptcy stays on your credit for 10 years. However, most people recover about 2 years, and sometimes even earlier. Like FHA will do mortgage loans again 2 years after a Chapter 7. Most other lenders are in the 2 to 3 year range. So I don't sugarcoat it. There's obviously consequences to filing bankruptcy, but it's something where most people recover much, much sooner than they think they will. So, all right, let's jump into some of the questions. We've got Dave Lamb, regular here. Thank you, as always, for supporting the channel and being here each and every week. Sincerely appreciate it. We got to jump into Goshen here. He was here early. I saw these questions coming through very quickly. He says, thanks for your work. Thank you, Goshen. Plaintiff original creditor was denied summary judgment, no affidavit of debt, which I pointed out. Should I just prep for trial or for a motion or something? And in a motion to compel private arbitration, does the pleading start over or transfer? One more, not within the motion, but when the arbitration begins, to be clear. Okay, so congratulations on that. Winning the motion for summary judgment against an original creditor debt collection suit is very difficult. Frankly, when we get them, we usually try to settle because they're generally going to have the witnesses and the documents and the evidence they need to be able to establish their case. And so often I'll recommend a settlement approach to it. So the fact that if they didn't have the affidavit, if they didn't have appropriate evidence, and sometimes they see that where creditors' attorneys will get a little lazy with things, particularly if they're not going against another attorney, they think they can just, throw some things out there and the court will sign off on it. And sometimes they do. But as far as your question, what do you do now? So summary judgment, you won the battle, but that doesn't mean the war is over because obviously it's headed towards trial. And so you could prepare for trial, but you got to know that what the defects they had in summary judgment, as far as not having the affidavit, they're going to have a witness if they show up to trial. Otherwise, they're going to lose again. So I wouldn't plan on them not having a witness not show up at trial. It's likely that they'll remedy that problem that they had there. You could file a motion to compel private arbitration if there is an arbitration clause in the terms and conditions of the particular credit card that they're suing on. So that's something you'd want to look is get those terms and conditions. And at this point, if they file summary judgment, they should have provided you. Look and see if there is an arbitration clause, and if so, what it says. Who has to file it, where it has to be filed, whether there's AAA or JAMS, all that kind of stuff. And if you do file it, or if you file a motion to compel arbitration and it transfers over to arbitration, you do start over. It's two totally separate things. There's the judicial system, and then private arbitration is kind of like a rent-a-judge kind of thing. You're paying these people to resolve the dispute. And as we've talked about before, the reason why creditors don't like going through arbitration is because the rent-a-judge part of this is super expensive for the creditors. Both JAMS and AAA, the American Arbitration Association, the fees that they charge consumers are a fraction of what they charge like a creditor, a bank, a junk debt buyer, that kind of thing. So you would be starting over. It's a decent time to submit a settlement offer. If you've just won summary judgment, you put them back on their heels a little bit. And sometimes I'll follow that up with a settlement proposal of saying, look, clearly I'm going to fight this. We just beat you a summary judgment. How about X amount just to get it resolved? And in most jurisdictions, settlement offers are not discoverable or they can't be disclosed in court. It's Rule 408 of the Arizona Rules of Evidence and the Federal Rules of Evidence. I anticipate in your state it's probably 408 as well. But it talks about that, and it's because they want the parties to be able to talk freely and try to negotiate a settlement rather than pushing everything to trial. So there's no real harm in doing that. So Goshen, congratulations on that. That is awesome, and you're able to do that. Muriel, another regular. Thank you for being here each and every week. All right. Marion, the link, if you look at the very top of the thing here, it'll say Consumer Warrior Bootcamp. I will also put one down in the notes once we're done here tonight. If you want to take a look at the boot camp, which I said, like, it's good. That's going to be a all-inclusive, we're going to spend a solid 3 hours going through all this stuff. All right, let's see what Pancho Villa has to say. He says, I have a pre-conference tomorrow. The notice says that besides discovery, the judge may step in for arbitration. Can I still make an argument for actual out-of-court arbitration? Now, I don't know what state you're in, but that's a little bit of a different procedure that happens in Arizona. So I'm as I always say at the beginning, take it for what it's worth. Usually, if you're going to ask for the court to compel private arbitration, that's done with a written motion. The courts can take oral motions, but usually for something like that, they're going to want to give the other side a chance to respond before they're going to kick it out. And at least in Arizona, the pretrial conference in these types of cases is very brief. It's only done in the justice court system, which deals with cases under $10,000. And it's really just where the judge becomes aware of the case, sets some deadlines, that kind of thing. Sounds like in your situation, it says the judge may step in for arbitration. It's probably more stepping in for mediation. The difference being that mediation is where the judge or an independent third party will try to negotiate a deal or help to negotiate a deal between the parties. So that could be what's going on there. So, all right, Angie, hey, thank you. Thank you for being here as well. Dreamcatcher says, what if the arbitration term says that the costs are split? Now, if that's what it says in there, that's the agreement. So if you're going to private arbitration, you could be bound by that. Now, they may be talking about, because what you're going to have to look at, if you go to the AAA website, the American Arbitration Association, excuse me, or JAMS, it'll tell you, if you look up fees, it'll tell you what they charge. So they're not going to change their fees based upon what's in the agreement. But if it does say that they're split 50-50 and it's going to be really expensive to go there, it may be a better idea to keep it in the court. So that's why I'm saying it's really kind of a case-by-case basis. So, and that's kind of to follow up your question there, as far as what it is. All right. Let's see here. Let's see what Marion has. Hi, John. I'm in Florida. I have one lawsuit so far. Thanks for the introduction question of whether or not to file. Should I get a car before or after? Now, bankruptcy is interesting. It's a good question, Marion. Bankruptcy is a federal statute. It's dealt with by the federal courts, federal judges. But what's interesting is there are different exemption laws in each state. And the exemption laws are super important because the idea behind a bankruptcy is you're going to file it, get rid of all this debt, and then the trade-off is the court is going to look to see, and more accurately, it's a bankruptcy trustee is going to look to see if you have any assets that can be sold and the money given to your creditors. And most things can be protected through what are called exemptions. Like most people have heard of like the homestead exemption. In each state, there are different amounts of equity that are protected, and it varies widely. Arizona, they just upped the amount of homestead protection up to $250,000 of equity, which was awesome. But they did it at a time when everybody has like $500,000 worth of equity in their home. So it's not making as big of an impact as we had hoped. And then there are other states I've seen, I can't remember if it was like Tennessee or something, like it was crazy small. It was like $15,000. And then there's some states, which I believe Florida is one. I don't know for sure, but I believe Florida's homestead exemption is unlimited. And that's why a lot of people say people like O.J. Simpson live in Florida or in Las Vegas because they can own a home there and nobody, because parties have judgments against him, they can't collect against his home. I think in Nevada, it's like a $500,000 homestead exemption. Maybe not. Maybe I'm just making that up, but I thought I read that recently. So the question you're asking, that's the big wind up to answer your question. Buying a car or buying anything right prior to bankruptcy, you've got to be careful. I always say if you're thinking of bankruptcy, status quo is usually the best thing. Just keep things as they are. Don't be moving stuff around. Don't take your name off the title. Don't be acquiring a lot of things. Like, for example, in Arizona, one of the bankruptcy trustees' favorite little tools that they have is if someone buys a car soon prior to the filing of bankruptcy and the lender doesn't affix their lien onto the title, they can sell the car out from under you just free and clear. And I know that it seems like, oh, well, how does that happen? You'd be shocked at how, at least I'm shocked, how often dealerships don't put their liens on the title quickly. They have a limited amount of time to do it. And sometimes they even leave it up to my son actually just bought a car, and the bank gave the title, free and clear title, to us and said, take this down to the MVD and have them put the lien on it. And yeah, we did it. But I just thought, boy, that's a lot of trust they're putting in every single person that comes into their bank that they're going to actually go ahead and do that. So there's little things like that. I would definitely talk to a bankruptcy attorney before you get the car, and just make sure that you're doing things that, because they'll know in your jurisdiction how the trustees are, all that kind of stuff. All right. Let's see here. Oh, and you did a follow-up here. $1,000 for a car. And again, like in Arizona, you'd be fine. There's a $6,000 exemption for vehicles, and that's equity in the vehicle, not just value. And if you have like a handicap plate, it's up to $12,000. So but that's Arizona specific. So I would definitely recommend you contact someone there. All right. Let's go to this one. It says, how does the plaintiff find my employer for wage garnishment? Do I have to tell them? So in order to do wage, and that's what sometimes it's harder than people think to find out where you work or to find out where you bank. And so once the creditor, maybe even before they sue you, but once they get a judgment for sure, because they have to have that judgment before they can garnish your pay, before they can garnish your bank accounts, they will do quite a bit of research into you. They'll look at your credit report. Often I see like bank levies will happen. What they'll do is they'll go back and they'll look at how you paid them. If you paid them with a check, then they'll go back and say, hey, it looks like you bank at Wells Fargo. I'm going to go and try to levy and see if you still have an account there. So they'll kind of try to piece things together. They can look at your credit report and they may see, hey, he has a bunch of Bank of America credit cards. My guess is that maybe he has a checking account there as well. The employment information also shows up on the credit report. That's why the credit reports, you want your credit report to be accurate. There's a bunch of personal information they want you to put on there. And I always think, who cares if that's accurate? That's just a roadmap for the creditors, but you want the actual how they're reporting it to be accurate. But that they'll look for stuff like that. And they can do something, they can request what's called a judgment debtor's exam. It's a deposition that they can get after they have a judgment against you, and they can require you to turn that information over. So I don't see a lot of with junk debt buyer lawsuits, collection lawsuits. I don't see a lot of judgment debtor exams, but they could do it. They could even do what's called post-judgment discovery, or they could send over like an interrogatory that you'd have to fill out, providing the information on where you work. So my general rule of thumb is if a judgment's been entered, it's time to look at bankruptcy options or settle it quickly, because if they get a wage garnishment in, super tough to get that settled for anything that's reasonable at all. So, all right, looks like we made it. We got through all the questions tonight. Again, hey, I appreciate everybody checking in each and every week. And if you're interested in this boot camp, like I said, we're going to go A to Z through these things. It's been really deep dive. It's an interactive thing. It'll be done via Zoom. And we're going to do one on Thursday, May 19th from 6 to 9 p.m. Arizona time. And then the following Saturday, May 21st from 9 to 12. And you'll have a handout and be able to ask questions, and that will kind of walk you through some of the strategies that we have there. So, all right. I think that's going to end it for tonight. Again, thank you for checking in, and we'll